Good afternoon. Thanks, Zaza, for the invitation. My name is Isadora Fingermann, and I'm the General Coordinator of the Institute in Defense of the Right to Defense, a Brazilian NGO based in São Paulo. I was asked to do some brief appointments about the Brazilian legal aid system, especially in São Paulo, and about two pilots that we have run in São Paulo. First thing I want to highlight in this presentation is that under Brazilian law, the technical defense is only mandatory during the penal action and during the sentence execution phase. Thus, when an accuser does not designate an attorney of their choice, the Code of Criminal Procedure mandates that the court appoint them a defender, who can be either a public defender or an assigned counsel. However, the presence of a lawyer in the police interrogation, as I just said, and in the whole investigative phase is not mandatory. Besides that, free legal aid for those who cannot afford to hire a private lawyer is assured by the Brazilian Federal Constitution in Article 5 and by the Code of Penal Procedure in Article 263. Although there is an eligibility criteria for other areas, that's about $900, this does not apply for criminal procedures. Everyone accused in a criminal procedure who do not designate a private attorney will be entitled to a public defender, regardless of their family income. In 1988, the Federal Constitution established that all legal aid services for indigent people in proceedings before state courts should be performed by the state's public defender's office. The state of São Paulo, however, only created its public defender's office in 2006, and until then, the public service of legal aid was provided by the Office of the Attorney for Legal Aid, linked to the Office of the State Attorney General, the body responsible for representing the state of São Paulo in courts, and in a supplementary manner by lawyers participating in a scheme executed with the Brazilian Bar Association. Because it was created just a few years ago, the number of public defenders is not sufficient for the demand, and the Brazilian practice remains being the appointment of a court-appointed lawyer through an agreement and a scheme with the Brazilian Bar Association. So we have, as you can see in the first slide, public defenders in our system who are public servants, bachelor's degree in law. They must have passed a very hard civil service examination, and they are controlled by external public ombudsman office and have training curriculum. In São Paulo, as I said, we just have 719 public defenders for the entire state, with over 43 million inhabitants. From them, approximately 250 are in the criminal area. Specifically in relation to police inquiries, there are only 4 public defenders responsible for all the demand in the city, over 11 million inhabitants. Another extremely overloaded area is legal aid for the correction stage. In the city of São Paulo, for example, only 17 defenders act on behalf of 70,000 prisoners. Therefore, the scheme with the Bar Association for the provision of supplementary legal aid seeks to meet the demand where the services of the defender's office are insufficient. The problem is that, differently from the public defenders, these court-appointed lawyers are not public servants. The only legal requirement for their qualifications is that they must have passed the Brazilian Bar Association examination. And after that, there is no quality control and no training curriculum or professional guidance offered. So while we have 700 public defenders in São Paulo, we have almost 45,000 lawyers assigned in this mentioned scheme. Most of the legal aid service in the state of São Paulo are still provided under Bar Association scheme, and it's a situation that proves problematic. First, because the assistance under this model should be for supplementary legal aid only. Second, because it's reasonable to assume that there is a greater risk of poor technical quality in the services provided under this scheme than in those provided by the Public Defender's Office. Going to the second slide, please. The second thing that in my point of view, it's important to explain you, before I explain the pilot, is the timeline of the first stages of criminal proceeding in Brazil, so that you can see the moments where the legal aid is more needed and less provided. After the arrest, we will have the police interrogation. As I already told you, the presence of a lawyer is not mandatory in this moment. There is the right to a lawyer assured by the Federal Constitution. But since the Bill of Rights is usually derived by the police chief after the interrogation, and in overly technical language, field defendants understand and make use of this right. Then the police send a printed copy of the prison papers to a judge and the defender within 24 hours from the arrest. Note that there is no custody hearing in this moment. And this is the moment when the public defender should request the temporary release of the defendants. In practice, what we see, at least in São Paulo, is that they are only able to request the release in 50% of the cases. Then we have the filing and the acceptance of the indictment and the start of the penal action, and the filing of a reply to the charge by the defense, the moment when the defense witnesses are selected. Here, again, it's crucial to note that the defense is drafted without any contact between the defensor and the defendant. And finally, we have the hearing, the moment of the first contact between the defender and defendant, and between the defendant and the judge, which takes place in average 4 months after the arrest. Going to the third slide. To end my presentation, I just want to tell you some main information about 2 legal aid pilots projects run by my NGO. The first one is called SOS Freedom in English. It happened in 2011 and 2012, when we placed volunteer lawyers for 8 months in a temporary detention center, where we assisted 537 individuals right after their arrest. We wanted to assess the impact of the law of precautionary measures. Here I have some data from the profile of those detained in the prison. Besides the fact that we have a very specific detainee profile, since, as you can see, 74% are between 18 and 34 years old, 84% earned up to $900, 63% had only completed primary school, and 6% were mixed race or blacks. I think the important point to highlight here is that 93% of them did not have a private lawyer, meaning they depend on the legal aid provided by the Public Defense Office. From these 500 persons that we interviewed in the facility, we worked in 344 judicial cases, obtaining precautionary measures alternatives to detention in almost 45% of the cases. The problem is that from this number, 31% were bail. This data is a concern, given the unequivocal low financial conditions of these defendants to pay the bail. So they remain in prison because they don't have the money. And the fourth slide, last one, it's the second pilot that we called First Defense. This is happening right now. It started just last month. And in this pilot, we want to diagnose the effect of the presence of a lawyer at the police station during the police interrogation. There are 35 volunteer lawyers assigned to 5 police stations in the city of São Paulo who have already done 16 6-hour shifts. We have some preliminary results, remembering you that we have been working just for 2 months up until now. We are running 8 cases obtained for bails, non-precautionary measures different from bail, and 7 freedom requests and 6 habeas corpus presented by our lawyers. Our goal, in the direction that Libby just told us that happened in some countries in Europe, is to propose an amendment in the penal procedure law to make it mandatory to have the assistance of technical defense and therefore legal aid in the preliminary moment of the police interrogation. I think these are the main points I want to tell you in a 10 minutes presentation, but I remain here for eventual questions about our legal aid system.